So thank you for joining us today on the FinCEN Report podcast. I am Jonathan Wilson, and today we're going to be talking to Tony Soukenik. Tony is a partner in the Sandberg Phoenix law firm in Clayton, Missouri, and he's been very active getting his law firm ready to help their clients comply with the Corporate Transparency Act. And one of the topics we're going to be covering with Tony is a lawyer's ethical duties under the Corporate Transparency Act. Now, generally speaking, a lawyer's ethical duty includes the duty to inform the client about the law. Obviously, that's why lawyers exist. But in the case of the Corporate Transparency Act, it can create some tricky conundrums because of the way that time passes under the Corporate Transparency Act. For example, a company that is formed after the implementation date of January 1, 2024 is going to have to disclose the identity of its company applicant. And the term company applicant means the individual who files the document that causes the entity to be formed in the first place. Now, in many instances, the company applicant is going to be the lawyer who actually files the document. When that happens, the lawyer might have an ongoing attorney-client relationship with the company or might not. In the case of an attorney who files the document to form the company but then has no ongoing relationship, what ethical duties does that attorney have to the company long after the fact? Those are some of the topics we're going to be covering today with Tony Soukenik, so stay tuned. Okay, so Tony Soukenik, welcome to the show.
Thank you.
Where are you calling from today?
I am calling from St. Louis, Missouri.
So Tony, tell us a little bit about your practice and your interest in the Corporate Transparency Act.
Well, my practice is varied. I would describe myself as a general practitioner with about 15 various disciplines and multiple teams that support me from this 180-person law firm. So I'm quite fortunate to have those resources. My practice is generally businesses that are small to medium-sized businesses, many institutional businesses, many banks, but by and large, family businesses, multiple generational businesses. So that's my practice. Can vary in any given day. One day I could be working on some kind of environmental matter that one of my family businesses encountered, and the next day zoning, the next day a prenuptial agreement, the next day a merger and transaction. But by and large, small to medium-sized businesses. Also, homeowners associations. That is going to be a target of this Corporate Transparency Act.
One of them. Yeah. And now your 180 law firm in St. Louis is called Sandberg Phoenix. Are all of your lawyers there in St. Louis, or do you have offices in other locations?
We have offices in Kansas City, virtual employees working in Jefferson City, virtual employees working in Union, Missouri, offices in Clayton, Missouri, offices in downtown St. Louis, and then 2 offices in Illinois, Southern Illinois, Edwardsville and O'Fallon, Illinois. So
you got the middle part of the country covered.
Generally.
Yeah. Now, you and I have spoken a couple of times about the Corporate Transparency Act. I would say that your firm is sort of on the cutting edge of firms that I've met that are getting out in front of the issues and preparing in advance to advise clients. For the benefit of our listeners, what are some of the things that your group there at Sandberg Phoenix has done to get ready for the CTA?
Well, Jonathan, to be fair, we're probably one cut behind your firm and your efforts, because I view and we view you as the leader of this effort. But
you're very kind. You're very kind.
You have been the catalyst to cause many a stir in our office to think about how to really what's our obligations to our clients and how to take this opportunity and use it to better service our clients, to better organize our clients, and as a marketing effort to do succession planning with our clients. By and large, our focus has been to inventory those clients that would likely have to do an examination of whether or not they fall under one of the 23 exceptions or exemptions under the CTA. And then after considering our active clients, considering what our obligations may be to our dormant clients. In particular, the one exception comes to mind under the CTA having to do with inactive entities, and it's a 5-prong definition that seems to require analysis almost as much as the analysis of whether or not a company is one of the exemptions under the 5 million in sales prior year and 20 employees. So again, the inventory has been a large concern, and that's what we're doing right now, putting together our lists, and we have put together various types of informational brochures. I don't know that we really have done a blog from our firm. We find that that requires clients to actively be looking at our website. More importantly, I think we need to be communicating with our clients in every form and fashion. I'm working on putting a byline in our billing. Our billing is electronic in the most part to our clients, but some kind of notice in the billing to just let them be aware that they should follow up with us.
Oh, that's a great idea. Just like a line at the bottom of the invoice. Yeah. If you haven't already done so, check out the Corporate Transparency Act, something like that.
Something to that effect. And, it's a great opportunity to consider other compliance issues as well. FBAR being one of them, the foreign banking acts, and what are our clients' obligations as well in that respect. But more importantly, under the CTA, we are presently considering what is our obligation to our clients, and what is our obligation if our client is not in compliance, and getting ahead of that for that time when we get past December 31st, 2024, and we're still working with a client that we have some sense that they perhaps have not paid attention to this compliance, notwithstanding our multiple warnings. Should we consider continuing to do work with that client? Should we be altering our engagement letters with our clients, sending amended engagement letters to our clients? This is an opportunity to clean house and get our own compliance in place as to our engagement letters.
Sure. Now, I know we had spoken a little while back about the ethical duties that lawyers have, both to current clients, former clients, and so on. Why don't you describe for folks what you were contemplating there with getting advisory opinions from your state bar?
We are in the process of, we have reached out to the state bar for purposes of just general discussions. They have found that our discussion about the CTA stimulating and applicable to all the lawyers in the state. And if once we send a letter, we would expect that they would want to respond within the guidelines of our ethical canons and to describe what our obligations are. One of the things that we've considered in preparing the letter, reviewing the letters that we want to send, is we ran them by our general counsel within our firm. And of course, one of the concerns was, well, if we send this letter out and they ascribe it to Sandberg Phoenix, does that create a higher bar for us in the future? So our
you shouldn't be penalized for asking a smart question.
That you would think. We have followed up with the counsel for the Ethical Bar Association, that forum, and we are assured that the response will be anonymous as to the inquirer, so it will not be ascribed to or related to our firm.
Notwithstanding this podcast that tells the entire universe
that tells the entire universe that we are now doing this. Yes. But it caused me to review the canons, and looking at them, there's one canon that says, as a representative of clients, a lawyer performs various functions. As an advisor, a lawyer provides the client with informed understanding of the client's legal rights and obligations and explains their practical implications. Mm-hmm. And that would be one such. And there's not any canon that just comes straight out and says, you've got an obligation to tell all your clients this, but it's there in so many ways, just as the one I just read to you. I also notice under our canon of ethics, upon termination of representation, a lawyer shall take steps to the extent reasonably practicable to protect the client's interests, such as giving reasonable notice to the client. The mere fact that we should really consider whether or not we have terminated our relationship with clients and our obligations is an opportunity for us to refresh whether or not we have an ongoing relationship with them. And the way we communicate going forward could be something along the lines of, dear client, we've not had any activity with you since we've not been performing any services for you in almost 10 years, 20 years, whatever the case may be. But notwithstanding that, while we're no longer, currently representing any particular item, you should consider perhaps the CTA, and we wanted to bring this to your attention. And, some way of dealing in that form or fashion. We think it's important perhaps to amend our engagement letters so that we talk in terms of what is the scope of what our engagement currently is. We find that it's in Missouri, it's under Rule 4 of the Canon of Ethics that most of this would fall. And we find that there are plenty of opportunities for us to inquire with the Bar Association to get some opinions and get some value for that annual fee I pay for the privilege of having a license.
That's right. You got to get something out of that. Yes. Have you actually filed your motion or filed your letter yet? And if so, when would you expect to hear back?
I would expect to file it sometime next week.
Okay.
So in the course of anything that is new, everybody is looking at it. What are the unintended consequences of this inquiry? As the first question that came out of the box was, is our name going to be attached to it? Will that cause us to be brought to a higher bar? Sure. And we've settled that reasonably. We're considering whatever other consequences there are. We've shared with you, Jonathan, some of the letters in three different categories. One is, what is our obligation to our active general clients? What is our obligation to our past clients? And then what is our obligation to continue to represent a client that we know is not compliant with the CTA?
Yeah.
And for us as lawyers, Jonathan, I don't think we will always have the knowledge that our colleagues in the accounting world will have, because obviously they have more information about our clients, whether or not they had 5 million in sales reported in the prior year, or whether or not they are filing withholding for 20 or more employees. Our accounting colleagues certainly have more of that information than we do.
Well, it's interesting because on the one hand, you feel like you should be telling clients, what the law is and things to watch out for. On the other hand, there are tens of thousands of laws out there, and a single lawyer can't possibly be cognizant of all of them. We don't know what our clients do. A corporate lawyer at our age of seniority has often formed hundreds of LLCs and corporations. I hope they pay their taxes, but I don't really know if they do or not. I never would have thought it was my job to, pick up the phone and remind them on April the 14th that they need to file. And yet, some of the pundits have thought that with the Corporate Transparency Act, there's more of a duty there. So,
well, and I agree with you, Jonathan. I think there's an expectation that most of our clients realize they have to file their tax returns, but I don't think ever before, at least in the 37 years I've practiced, that I can think of an act that would catch clients unknowingly, unsuspectedly, that they had a duty or an obligation to share such private information as their driver's license or their passport, and then a following duty to keep their address current.
Exactly. I looked up this statistic not long ago that something on the order of 10% of the U.S. population fails to pay its taxes every year. Now, if 10% of us can't get our tax returns done, what percentage of us are not going to get our first beneficial ownership report done on time?
It will absolutely be substantial. I think it may be in Alabama that they're considering some court action on trying to stay this CTA, and certainly there is, as we're growing closer to the deadline, there are more and more organizations that are writing their letters to FinCEN about this situation. But at the end of the day, we've had this type of compliance in our country for more than 20 years in the various bank secrecy acts, and the obligation has been on the financial institutions.
That's right.
For the very reason they're exempt from having to report themselves, they have long been the subject of this compliance. So I don't see it going away, Jonathan. Do you?
No, I don't. People ask me this all the time. The law was passed with a bipartisan supermajority. It overcame a presidential veto. So probably a majority of Congress sitting today has already voted for this statute. And when FinCEN was late in getting the regulations done, they hauled him Das in front of the committee and asked him, what was taking so long. He complained about his budget. So they increased his budget by 30%. And then they wrote him a letter co-authored by Marco Rubio and Elizabeth Warren saying, hurry up and get it done. So I don't see Congress having any appetite to step back from the brave new world that the Corporate Transparency Act represents. I think it's going to be full speed ahead, and we're just going to have to figure out a way to make it work.
Oh, well, then that leaves it really the only chance that something might change, barring some court action with some federal court, perhaps in Texas or otherwise, that generally is there to bar these things, would be some action, some further regulation from FinCEN. But I'm sure they're hesitant to come out with any more proclamations until they've digested all the unintended consequences of what they've already shared.
Well, they've had over 2 years to think about the unintended consequences. At this point, they should be full speed ahead, finalizing the access rule, finalizing the database that they need to complete before the end of the year. You mentioned the litigation. It's a case that's pending in the Northern District of Alabama, I believe, and we've covered it on the blog at FinCENreport.com. I kind of think it's a long shot. The thrust of their argument is that the practice of forming a corporation is an intrastate act, and therefore Congress doesn't have jurisdiction over that intrastate action. I don't see how that flies from a constitutional point of view.
No, and any kind of resulting judgment would be limited to intrastate acts, as opposed to our many entities that are intrastate. So,
exactly.
And that might just come out to be another prong that we have to examine before it's all over. But as a practical matter, we're gearing up for this. I think we had almost 100% of our business department, well over 50 attorneys, attend your seminar, and they were all impressed by it, Jonathan. and everyone is motivated and frankly just waiting on the next steps that we're going to suggest here at the firm. So I see coming out of the box next week something along the lines as requesting those formal opinions on behalf of the bar generally for the benefit of those in Missouri. And once we see what kind of response we get there, our sense is that we'll apply in Kansas and Illinois just the same. There may be some questions that are asked, or there may be some pushback, and we may have to refine our request. Mm-hmm. But once we are done testing Missouri, we'll send it to Kansas and Illinois. And I would encourage the accountants to send it to their AICPA chapters just the same, and mm-hmm. get the same type of proclamation so that we have that same information. Jonathan, I've talked to 2 small CPA firms. They have about 20 employees. Neither of them had this on their radar screen whatsoever. Right. And if the CPA firms don't have it on their radar screen, it tells me we have a long educational process, not only for the CPAs, but for our clients.
Well, Tony Soukenik, thank you so much for sharing your thoughts with us today. When you get a ruling back from the Missouri Bar, we'll have to have you come back and tell us all about it.
We look forward to sharing that information.
And Tony, thank you for joining us. We're going to have your information here at the end of the broadcast.
Thank you, Jonathan.
Thank you.